Yes. Sorry, I was still connecting to audio.
Mr. Bondura, can you hear us?
Yes, Your Honor, I hear you.
Good morning. We're starting just a little bit early because everybody's here. I do have proposed orders. Did you get a copy of those, sir?
Yes, there's a couple reasons why I didn't sign one of them, but I couldn't sign the other order or the other documents. I wouldn't sign one of them. So I did get them though, Your Honor.
Okay. So what issues do you have with? I'm looking first at the temporary family law order.
It looks like everything is correct, but it looks like Miss McLean tried to sneak in a new brand new year on that order without utilizing the original date.
On
I think he's referring to the restraining order.
that may be
His email.
yeah, that may be I don't see any dates on the temporary order.
I mean, the original protection order, Your Honor, started in August, and I was kind of curious as to how the expiration managed to be in September, but I kind of like let that one go. But I think I got Houdini'd on one extra month again when she put in the temporary restraining order or for part of the parenting plan. But the original protection order is the date that I thought we were going off of, but I guess I'm wrong.
Again, I think he's referring to the restraining order at paragraph 3. The court did not indicate that you were identifying a specific date or changing that provision at the time of the hearing. You ordered me to change the language first off at 4 under notice to reference that he was present for the hearing. And then at number 5, you ordered that the language identify or be the same as the protection order. So A 5A 1, 2, and 3 is the language that is from the protection order. There was no argument about paragraph number 3 or establishing a specific date.
Normally on these orders that are in the course of a dissolution, they generally are set to go through the course of the case. But the state requires that we have an end date of some date. So this order would, if the case concludes prior to 12 months, it would have to either be renewed at that time or ended at that time. But the 12 months is not that's not adding anything. This would not normally expire at all as long as the case is pending.
I'm confused, Your Honor. Does that mean I have two separate expiration dates? I would have the family the temporary restraining order and the protection order. That would be two separate.
That is actually correct, sir. It's problematic having two orders, but that unfortunately is how the state of Washington has decided to set up their structure. But the language in this order appears to be the same as in the other order, which was really my concern, is so that we didn't have different language as to what the order was saying. So,
well, it is critical for me to understand when things expire, though. Otherwise, that's how I put myself into bad situations a year from now.
Well, this one is 12 months unless it's renewed.
Okay, but when does it expire? When does it expire, though, naturally, if this case is dissolved?
It would expire if the case was dissolved unless there is a new order entered in those final orders. So it's either at the end of the conclusion of the dissolution matter or at 12 months from today. And then if there's a request for this to continue beyond that, that would have to be addressed separately. That's not in front of me today.
Well, like I said, right now, there's no reason. There's no, I can't see the child. So, I mean, it doesn't, as long as it falls off eventually.
Mm-hmm. Yeah, it does. Like I said, the 12 months is just the state sets that up as a default. And Normally, in a case like this, there wouldn't be an expiration date, except if we don't have that, then law enforcement has challenges managing them. The state, they want an end date. So,
Okay.
so that's not something anybody's. That's just normal. So, and again,
Okay,
if it's done prior to that, then this order would end, and unless there's a new one, there wouldn't be one unless there's a new one issued at that time. So, okay.
Yep.
Everything else look all right?
Everything else looks fine, Your Honor.
Okay. It looked right to me. So but I want to make sure. So let me tell you that. Please, the first.
Yes, sir. 12-1.
What happened? I'm serious. I don't know what happened to the month. So on the other order, the temporary order, the only thing really in that order is that it sets over essentially everything to next Tuesday. Defers fees until future requests are reviewed. Is that one all right?
What was that? Yes, Your Honor.
Okay. All right. So I've signed those two orders, and they will be filed a little bit later today. We're over at Juvenile today, so I don't know what time those will actually hit Odyssey, but
we will provide Mr. Bondurant with a confirmed copy by email once we have those available.
Okay. So I have signed those, and those are going to my clerk right now.
Thank you.
Okay, Your Honor, I do have one quick question, though, actually. So remember we mentioned that on the 5th that we would have a court case. I was going to ask if it would be possible to move us to the top of the docket. I actually don't start work until 10 o'clock that day. And if we could be managed to squeeze our case in early on that day, I'd be able to do both. So I know that I could probably only I can only request it, but I mean, that's my request.
It won't be my docket, but we'll put a note on the case, and I believe it'll be Judge Evans. He can see that, and he's pretty good at managing that docket. So, if one of you can make some noise at the beginning of the docket and request that, and it'll typically be handled.
Awesome. I thank you, Your Honor.
Okay. You have a good weekend.
Is there 1 week or 2 weeks?
Let's do a 2 week at this point. I keep getting sicker rather than better, so let me do a 2 week.
Okay, and then I think we have Ms. Knowles. This is your case, and I see you on there. Dion Rardin and Rebecca Knowles. Are you able to hear the court? We can't hear you. If we can see you, you might need to hit *6 to unmute if you're on a phone. I know we don't hear you, ma'am. That's what I'm telling you. We cannot hear you. I can see you. Okay, hold on. I'm reading something from you, Ms. Knowles. Ms. Knowles, I can't hear you, but I read what you've written. You're indicating, ma'am, I can read your lips. I understand that you're using swear words. Please don't do that in court. Does Mr. Rardin, is he able to, can one of you give me a thumbs up if you can hear the court? So Ms. Winkles, the response that I'm getting from Ms. Knowles in her typed statement is that she wears hearing aids and it doesn't work well with Zoom. And so she's asking for in-person.
There is a transcription available, closed captioning available for Zoom. In person is bad with me considering I have pneumonia at this point.
Yeah.
I'm not sure in person would ever be a possibility for me given that I get sick more than I don't get sick. But there is closed captioning. Additionally, she has the option of always coming to court since these are open. So I'm not sure why that would stop anything.
Yeah, last time I was here.
Okay. I'm gonna mute. Okay. Here's what I'm gonna do. And Ms. Winkles, you said 2 weeks?
Yes.
Okay. I am gonna set this matter over 2 weeks to December 15. I'm gonna have the court Let's see if we have contact information for Ms. Knowles on her.
You can hit AI companion at the bottom and it will allow her to see the transcription, and also show captions will allow her to see the transcript of the hearing as it goes on. So hopefully she can hit that.
It says that we've enabled closed captioning. Ms. Knowles, can you give me a thumbs up if you're able to read what we are saying? Okay. We are going to set your case to December 15th. That's 2 weeks from today at 9 a.m. You can come to court in person, but we won't have this type of transcriptionist available that you have on Zoom. So it may be better if you appear on Zoom to read the closed captioning.
Your Honor, would you mind if I jumped in as a friend of the court here?
Please do.
Ms. Winkles, any objection?
No.
I don't know if you can read this, but Ms. Knowles, I am a free eviction defense attorney. If you come into my office, we have devices that can, we have deaf translators available for you so we can communicate. I understand that calling into the line may be challenging for you. So if you could stop by my address, which I will put in the note, or which I will put in the chat, we can get you set up with an attorney. Okay?
Okay.
Thank you, Ms. Knowles. I will put the address into the chat again. Please stop by. We have deaf interpreters.
Okay. Thank you, Mr. Kiernan. We will see the parties back on December 15th.
All right. Thank you, Your Honor. I don't think I have any other today. That's it, correct?
Oh, let me just take a double. Yep, that is it.
All right. Thank you, Your Honor.
Feel better. Okay, I'll turn it over to the parties now. Are there any other requests for strikes or setovers? And we'll take care of those matters first.